Satchak, I hope I pronounce it correctly, Dominic, it's easier maybe, as a guest at my institute. And of course, just by chance, I was last Monday, I met Judge Hofmansky, which of course is from your university, and we talked to him, and he's aware of this meeting, but of course he is very busy, so he of course has other things to do than to be in a kind of academic meeting to discuss Ukraine. But you know, I know him for a long time before he was at the ICC, and when I was still working as a research assistant at the Max Planck with Professor Eser. And I also, of course, followed your case at the European Court of Human Rights. So it's human rights. So it's a special honor for me to be invited, and I hope we can strengthen our relationship institutionally speaking. You know, and of course, all the investigators and researchers from Krakow are always welcome. In Göttingen, we have very good libraries, not only in foreign criminal law, international criminal law, also in public international law, where Dr. Lippold is taking part from the International Law Institute. So you are always welcome if you want to do kind of comparative law research. So, but that's maybe for another day. We can still talk about it. Now we have to come to our topic, and I want to share my screen and show you a PowerPoint presentation, a very basic PowerPoint presentation I have prepared. So this should so now you should see Ukraine and international criminal law. Can you just give me a sign that you see this? Okay, great. So what I will do here, I start a little bit with the basis international law issues. And this is really very basic, but I think before we actually go into the international criminal law discussion, we should look at the public international law situation, which is of course defined by the UN Charter, Article 2, the prohibition of the use of force, which has been violated without any reason, justification by the Russian Federation. And then we come to Article 51, which is very important in terms of the collective self-defense invoked by, of course, Poland and other states helping Ukraine. I mean, this idea of collective self-defense, which we know very well, also in criminal law, self-defense or defense of others, of people who are attacked by others. So that's just the same idea. And on this basis, basically, then we can talk about a series of measures, including supplying weapons to Ukraine. I mean, we can go into detail about this later in the discussion. Where are the red lines? As you know, there is a more restrictive position still in Germany than in Poland, perhaps, on this issue, and this could be discussed, of course, with a view to Article 51, but also with a view to international humanitarian law of armed conflict. The issue which has been very important here is the question: when are you becoming a party to the conflict? Okay, these questions, of course, are interlinked. Then we have the question of reactions. First of the UN Security Council. As you know, the Council did not approve the resolution which condemned the invasion because of the veto of Russia as a permanent member. It's a substantive resolution under Chapter 7, and therefore Russia can veto it. But still, it's worthwhile looking at this resolution. It's worthwhile because it's practically the basis of the later General Assembly resolution, Uniting Pro-Peace resolution. And I just go through it very quickly. You have it. I can, of course, share this PowerPoint with you. That's just the text of the resolution, but importantly, referring to the territorial integrity of Ukraine, Russian Federation shall immediately cease its use of force, refrain from any further unlawful threat, withdraw all of its military forces, and also deploring the status of certain areas in eastern Ukraine, and so on. Again, it has not been approved. There were 11 votes in favor. There was a majority, but since it's a Chapter 7 resolution, it could be vetoed by Russia. Then we have a unanimous decision by the Security Council, but basically that's a very recent one. But that basically is giving, in a way, legitimacy to the Secretary General, which may not be underestimated, because, as you know, the Secretary General, which is a Portuguese national, has been very outspoken against the Russian aggression, and Russia has criticized him, let's say, exceeding his role. Being Secretary General, he has to be neutral, yeah, and so he was criticized for his very clear stance against the invasion. And so it's certainly a success that the Security Council adopted this resolution, expressing strong support for the efforts of the Secretary General in the search for a peaceful solution. It's not, of course, any operative resolution, but it's an important document. And then we come to the General Assembly. How do we get to the General Assembly? We have in the Charter the possibility that the Security Council, based on a precedent of the 1950s of last century, Korea War, can refer a matter to the General Assembly if the Security Council is unable to act, and that's the situation here. And the referral decision of the Security Council only requires a majority, and the permanent members cannot veto it because it's considered a procedural decision. That's the reason that the case or the situation is referred to the General Assembly. Of course, otherwise Russia was, of course, not in favor of referring this to the General Assembly, but since it's just a procedural decision, the General Assembly was authorized to take part, and we had this famous Uniting Pro Peace resolution, which, and that is interesting, got an impressive vote in favor, 141, and interesting compared to the Crimea annexation resolution. If you remember, when the island Crimea was annexed, the General Assembly also had a resolution, but we had less support, i.e. there was less explicit opposition against the annexation, and there were much more abstentions. So certainly this resolution is a success from the perspective of the West, if we want to put it that way, in that it got a lot of support. But still, we shouldn't be too over-optimistic. I think we tend to be, especially in Europe, to have a very Eurocentric version, or in Germany, a very German version of events, and we speak of the international community and as if we speak basically of the NATO, no? And if we look around, we see that very important states still have abstained. And especially I want to draw your attention to South Africa, which of course is a democracy, is an important state, a very important state, also for the International Criminal Court, and it has abstained. And then you have also Angola. So you have some African states which clearly have abstained because they feel a certain loyalty versus the Soviet Union as the country which supported the anti-colonial struggle against us. That's the truth of the matter, against Portugal, Spain, England, France. Angola, for example, is a former Portuguese colony, as you know. South Africa as a former apartheid regime, which was supported by Western either governments like Franco government in Spain or the Salazar dictatorship in Portugal. And on the other hand, the resistance really was supported by the former Warsaw Pact, which is highly interesting speaking in Krakow, because of course Poland was part of this bloc, and the Polish position, it would be interesting to historically look at the position of Poland, if it had a proper position different from the Soviet Union at that time, as to the colonial struggle. And then you have other countries abstaining for political reasons, like Nicaragua, where you have a government which itself is a kind of dictatorship of Daniel Ortega, and which of course depends on Russian aid. And interestingly, Venezuela, which is another state which very much cooperates with Russia, a little bit comparable to Syria, you know, which of course voted against. Syria even voted against, of course, because the Russians are in Syria and the Russians are basically backing the Assad government. But Venezuela did not even show up. You see, Venezuela, there is no vote recorded. And that means the Venezuelans did not show up. But the Venezuela is certainly a state in favor, or at least abstaining, because it's a state which is basically supported by the Russian Federation and by China. So these are just details, but you could go through these states and you would see that contrary to the impression we get if you read the Western media, the German media, I'm talking, you can tell me what the Polish media say, things are more complicated. So there is, of course, a certain united front, but I wouldn't say that Russia is isolated. You know, that would go too far. And you can clearly see it here. And then you also should consider that you have states like Turkey, while they voted in favor and are part of NATO, are of course also in a kind of negotiating position. As you know, now Turkey is trying to hold a Swedish and Finnish accession to NATO. So things are more complicated. We should take into account. Anyway, the General Assembly resolution as such also is important. Here is a reference to the precedent of 1950, and then you have also the Friendly Relations Declaration reference, where the act of aggression has been defined, which then is the basis of the crime of aggression of Article 8 bis of the Rome Statute, which is important, as you know, for the discussion of a special tribunal, which we can also take up if you want in the discussion. Perhaps in the operative part, you have a condemnation of the so-called special military operation, reaffirming that no territorial acquisition shall be recognized as legal, grave concerns on attacks on civilian facilities, the scale of the attacks, etc., etc. And there is no recommendation for concrete action. That's also important. It is not a resolution which in any way concretely recommends either Chapter 7. I mean, there is a question if the General Assembly could do that. That's for the international lawyers. We have some in the room. We can discuss this. But also importantly, we have now a discussion about the referral power of the General Assembly to the International Criminal Court, which does not exist, as you know, but given the inability of the Security Council in certain situations, just think of Syria, because of the veto of the permanent members, and also Ukraine, and that is relevant for the crime of aggression. There are some scholars arguing that we should have a referral power of the General Assembly, which would of course mean that we have to change the ICC statute and so on. But anyway, that's just an important discussion which has been triggered and has been enhanced, if you want, by the Ukraine situation. So basically, this resolution is demanding from Russia to stop the aggression, to accept the territorial integrity of Ukraine, but it does not concretely, operationally give any recommendations. Perhaps we can discuss this again. Also, what is the value of this resolution? I mean, there is of course a discussion between international lawyers. And we have in this meeting some very able international lawyers, including from Göttingen. And so we could, of course, have a discussion, if you want, about this issue. Also, the involvement of Belarus, it's important. This is an interesting point also. What does this mean in terms of sanctions, or in terms of the collective self-defense of the West, if you want, against Russia as to Belarus, I mean, then Belarus is mentioned here in para 10, deplores the involvement of Belarus in this unlawful use of force. But then the question would be: so could Western states, although under Article 51 of the Charter, act against Belarus? And that's interesting to discuss. Okay, so that's the situation under public international law, and of course we have the position of Poland, which is very clear here. I mean, and you know that especially Poland criticized Germany for a long time in this regard, of being too reluctant to act. And that was the same position of Poland, strongly condemns this criminal aggression. That was a clear position already on the 25th of February, when in Germany we still discussed about if there should be a Zeitenwende, you know, if there should be a turn of times in German politics. And Mr. Steinmeier for a long time has not excused himself for his earlier errors, our president. So that took a long time. And Poland reacted very, very quickly on a parliamentary level with this February 24th position. Of course, I do not have to read this here. You know better than myself the Polish position. Now let's go to the International Criminal Court. Let's first look at the jurisdiction regime. Under what conditions is their jurisdiction? Because there is an important debate going on, which is you know, perhaps bringing us other problems, being Western states, namely that Ukraine is not a state party, as you know. Ukraine is not a state party to the ICC statute, and that means that the jurisdiction cannot be based on Article 12, para 2, especially para 2a, the state on the territory of which the conduct in question occurred. You know, the ICC has a territorial jurisdiction regime as a principle, and we have some extensions. For example, active personality, that's this letter B, state of which the person accused of the crime is a national, but basically it's territorial jurisdiction. So i.e., as a rule, the ICC has jurisdiction if a state exceeds the statute, and therefore it has no jurisdiction over Russian territory, or over the United States territory, over Chinese territory, over Israel territory, over Indian territory, over Egypt, etc. And then you have this alternative Article 12.3 declaration, ad hoc declaration. So a state not being member of the statute could accept the jurisdiction by a declaration lodged with the registrar, and the declaration was done. There were various declarations by Ukraine, but the most important perhaps is the one of September 2015, so long before the invasion, because of course we know that the conflict remotes back to end of 2013 and 2014, when you had the declaration of the so-called independence. You have the support by Russian troops in the eastern Ukraine and so on. But interestingly here, and I want to draw your attention to this, there are two different versions of Ukrainian positions, and there is internal Ukrainian positions which are only in Ukrainian or Russian. So for myself, not accessible, except I use Google Translate. But I have read today a paper, a very interesting paper by a Ukrainian scholar in the Journal of International Criminal Justice, already pre-published, where he shows us all these different positions and shows that in the internal domestic Ukrainian kind of acceptance of ICC jurisdiction, they directly name people. I mean, they directly indicate certain persons, or they are targeting directly persons, while in the 12.3 declaration, which goes to the ICC, which you have here in front of you, let's say the international, for the, you know, for the international world, for the European Union and NATO and so on, it's just general recognition of the jurisdiction of the ICC by Ukraine. But here, senior officials of the Russian Federation and leaders of terrorist organizations, that would be the organizations in Eastern Ukraine. And this is interesting because, of course, and that's a big conflict, which it's getting more difficult. The ICC has to investigate everything, and the ICC should also investigate and will investigate, if you believe the chief prosecutor, possible crimes by Ukraine. And this is not, of course, excluded by the 12.3 declaration. A state cannot exclude this by just calling the other side, you know, like in this declaration, saying, well, it's all about the Russians. The 12.3 declaration under the statute, of course, enables the prosecutor to investigate both parties to the conflict, and therefore, in all the declarations by Mr. Khan, you will see that he stresses this. But here we have, of course, a conflict, and we can maybe also go into this a bit deeper. And also, why did Ukraine not sign and ratify the statute, not even after the invasion, you know? That's a very interesting discussion. And maybe I would be interested how this is discussed in Poland, because maybe in Poland there is even less criticism towards Ukraine than in Germany. But we should be aware that there is a problem. Now, I mean, if you want to become member of the European Union, you should ratify the ICC statute, for example. That's just a formal requirement. But why does Ukraine not ratify? And then the second question would be, if there is jurisdiction, as there is, based on the ad hoc declaration by Ukraine, how can the court exercise its jurisdiction? And that brings us to this issue of what I said before, Security Council referral. This should be amended if you want the General Assembly to have the power to refer, to have an Article 15 investigation. The prosecutor can proprio motu investigate, which was the initial situation in Ukraine, but which is a more difficult situation for the prosecutor. Or you have a situation which is now the situation of state referrals. So state refer one state or other, various states refer the situation to the ICC. We also had these self-referrals, Uganda, Democratic Republic of Congo. And that was a trigger which was finally used. And such a state referral, as I said, can be done by state party may refer to the prosecutor a situation. You just can see that there is no different distinction between a self-referral and a referral to another situation. So you could even imagine that, as we saw before, that the state refers its own situation to the International Criminal Court, which also is difficult under the complementarity regime. So another point which is contentious, but in this case anyway, that was not a situation, because as we had a situation, I just go to the statement of Khan of 2nd of March, when Khan intelligently or very elegantly said that I seek authorization to open an investigation into the situation in Ukraine. So that means that he started to act under Article 15 of the statute, where under Article 15, para 3, if the prosecutor concludes that there is a reasonable basis to proceed with an investigation, he shall submit to the pre-trial chamber a request for authorization. So that was the starting point, because Khan did not have any referrals. And before the invasion, that was not on the table anyway, you know. As you know, the ICC OTP investigates Ukraine since 2014, based on the retroactive ad hoc declaration of Ukraine, and there was also a report of crimes committed in eastern Ukraine and crimes committed in the Crimea island, about 3,000 deaths reported and so on. But this was also always a proprio motu investigation, where at a certain point, namely the point reasonable basis, Article 15, para 3, the pre-trial chamber must authorize. And that is not automatic. And we have this, if you follow ICC case law, you may recall the Afghanistan decision, where the pre-trial chamber rejected the authorization. This was then overturned by the appeals chamber. But it is possible that the judges just do not concur with the prosecutor and say there is no reasonable basis. So it's more difficult for the prosecutor to work under Article 15. There is an earlier judicial intervention, and therefore Mr. Khan intelligently referred to, made a suggestion. It would be significantly expedited if a state party to the Rome Statute were to refer the situation as provided in Article 14. That was on the 2nd of March, and then one day later we had this referral. So you know how this is interesting. This never happened before, of course, under the 20 years history of the ICC. And as you know, the first state referring was Lithuania, so a Baltic state, and this was then followed by these 39 other states, which the UK ambassador to the Hague sent a letter to the OTP, to the ICC, indicating that all these states you see here, so basically European Union and some others, some more states, refer the situation. And after that, we had, of course, the referral of Japan and still another state. So we have more than 40 states. That's a collective referral, which is unprecedented. We only had one collective referral so far, and that was a referral of the situation in Venezuela by Canada and some South American states, among others, Colombia, Argentina, and so on. But that was a very limited number, 5 or 6 states. But in any case, this collective referral is now a new, let's say, a new paradigm, and we have seen it in a very strong form here in the Ukraine situation. So then it was very quick that Khan, in the same statement, said he has found a reasonable basis to believe crimes within jurisdiction of the court had been committed and had identified potential cases that would be admissible. So actually, he closed the preliminary examination and came to the formal investigation. We have in the investigation phase 2 phases, namely preliminary examination and investigation, and that was also very quick, of course, compared to other situations we have in this Zoom meeting. People from the ICC or worked formally at the ICC, maybe they can explain in the discussion. So that was also unprecedented, how quickly Mr. Khan reacted. The only comparison, in my view, is to Security Council referrals, which we had only in 2 situations, namely Sudan and Libya. Of course, when the Security Council refers a situation, then there is much more, on the one hand, pressure on the OTP, and on the other hand, maybe more legitimacy, and then she may act more quickly. But they, even under these circumstances, the prosecutor did not act so quickly as under the in the Ukraine situation. And then he emphasizes the principle of complementarity and seek to engage with all relevant stakeholders and parties to the conflict. Investigations are conducted objectively and independently. Again, impartiality in both directions. Support of state parties and international community more broadly will be essential as we seek to meet the inherent challenges faced in the conduct of these investigations. I will seek the partnership and contributions of all states. And this is has then been let's say, even enhanced or strengthened the 25th of April with this famous joint investigation team. I mean, for us in Krakow, of course, you have enough experts on European criminal law. I had the pleasure to work with one of your colleagues in a book I wrote in English, and he helped me a lot with the Polish law on European criminal law. And you know that the joint investigation team is a mechanism we have under the European Union Mutual Assistance Treaty, the Treaty of 2000, the Convention on Mutual Assistance in Criminal Matters. And the first question here is, how is it possible that a non-member state can participate in such a chit? You know that we have this in transnational investigations, and Eurojust normally coordinates these investigations. You know, human trafficking, organized crime, all these Euro crimes, transnational investigations. Very often we use chits, and in these chits you have different enforcement officials from different member states. And here we have a situation where Ukraine, a non-EU member state, is part of such a chit. So the first question is this possible? And then you can consult Article 13, para 12 of the EU Convention of 2000, which says, I just quote, to the extent that the laws of the member states concerned or the provisions of any legal instruments applicable between them permit arrangements may be agreed for persons other than representatives of the competent authorities of the member states setting up the joint investigation team to take part in the activities of the team. In other words, on the basis of a special agreement between member states and the non-member states, we can have a chit with external states, okay? But that's certainly an exceptional situation, and it says, of course, nothing about the participation of an international organization, which is here also relevant, because this chit is as you can see from statement Mr. Khan, my office became a participant in the joint investigation group. Mind the word participant. So Khan very cautiously speaks of participation in the chit. He does not say became a member, okay, which is the term we use in the EU legal instruments. Membership in the chit means we have full rights. Yeah, every member of a chit. A very normal situation is a EU state, Poland, Netherlands, and Germany are in a chit, and the police enforcement officials work together on the basis of full access and mutual exchange of information, etc. Now, Ukraine is also a member because Poland and Lithuania, which set up this chit, agreed to give this membership to Ukraine, but the OTP is not a member. Why is it not a member? We don't know. Well, one hypothesis could be because there is a certain mistrust in the independence of a chit, which basically is led by Ukraine. Because what happens here is that who is calling the shots? The Ukrainian prosecutor general. I mean, you cannot imagine that on the territory of Ukraine, Polish investigators, Lithuanian investigators, or all the others, the French and all the 20 ones who are there and NGOs, can compete with the Ukrainians. Ukraine is a territorial state, and Ukraine, of course, has a right and a duty to investigate. And this is, of course, tricky. If you read all the documents, the one I just quoted to you, but there are much more documents where you clearly see that the Ukrainian focus is on Russian crimes, And if you ask, we have this interview with a Ukrainian prosecutor general, but what about possible Ukrainian crimes? For example, the treatment of Russian prisoners of war. We had something in the blog sphere. Then you will only get silence. So that is not a topic which is addressed. And that's a big, big problem. And there is another problem here, and that is that the basis of the chit is European Union law, but the specific chit is regulated by a specific agreement, as I just referred to in Article 13, para 2. But we do not know this agreement. And I can tell you, without giving you any sources, even the German Foreign Office does not know this agreement. So this agreement is not on the website of Eurojust. This agreement is not on the web. And why is it not on the web? I mean, we can just ask. Maybe one of you knows why it's not on the web. But the fact is that we do not have access to this agreement. If you compare to other agreements, any agreement, Spain, Portugal, Germany, that would be accessible, at least for the member states. I mean, we are all part of the European Union. How is it possible that our foreign ministry does not get this agreement? And the question which is linked to this is a question, why do other states of the European Union, like France, which sent many investigators to Ukraine, or Germany, which has a parallel investigation going on in Karlsruhe, and which also, via the Federal Criminal Police, investigates, why do they not participate in the CIT? So my question for you would be, or my call for you, or Mr. Robel, who is a very influential person in Poland, perhaps you ask the Polish, I'm not sure if you have good contact with this government, but you could try to ask the Polish Ministry of Justice, couldn't I get the CIT? Couldn't I see the CIT? I mean, it would be interesting for me academically to see what is in the CIT. So there are different indicia which create a certain distrust. The OTP is very reluctant. It speaks of participation because, of course, the ICC, the OTP must be very careful not to be partial here, okay? That would be, by the way, a big propaganda win for the Russians. So if we get a situation where the ICC would be partial, would only investigate Ukrainian crimes, that would not help the cause of international criminal justice. Okay, but anyway, so this is more or less background. In the declaration, this is, if I may say so, a little bit of blah blah for the outer world, but it doesn't address these issues. Of course, the CIT is unprecedented. It may enhance the ability to access and collect information, rapid and real-time coordination with CIT partner countries, but mine is only Lithuania and Poland, basically. It's only two countries, one of which is a very small country, Lithuania, and you have much more countries on the ground. Not to be a one-way street, but here the question is, since it's a participation of the OTP, it's not on the same level as membership. Will they give information? What kind of information will they get, and what kind of information will they get? Will they receive, and so on? And then we have the more recent declaration from a few days ago that actually I was in The Hague these days, and that was when the Dutch government, especially sent investigators, the Dutch Forensic Institute sent investigators to Ukraine, and that has been taken up the 17th by Khan, bringing this to the largest ever single field deployment. So what we have is, which seems maybe a bit funny, if you if you consider that Democratic Republic of Congo, which is much bigger than Ukraine. Ukraine is a very big country, and there are certainly many things to investigate, but it's a much smaller country than Democratic Republic of Congo. And if we have a situation where the OTP, with more than 40 investigators, has now the biggest investigation team on the ground, that shows how understaffed the OTP is. If you compare to a situation like Democratic Republic of Congo, even if it's only a part of the country. So this shows that, and it shows, of course, there is a unique support of this investigation, and it will allow us to collect more testimonial accounts, support the identification of relevant forensic and digital materials, and ensure that information evidence is collected in a manner that strengthens its admissibility in future proceedings. We will have effects of synergy of investigative action, which is, of course, highly contentious, because we have now several teams of investigators. As I said, France sent the Germans, the English, and there is no coordinating role of the OTP, not legally and not de facto, and also not of Ukraine. Even the Americans, via a kind of NGO constructions, now send investigators. They have this problem. They are not part of the ICC, and they must find another way. But so this is very optimistic, of course, to speak of synergy. If you look around, we have yesterday I heard also informally from the Germans that there is a lot of chaos right now in Ukraine in terms of investigation, because many people are there, many investigators, and there is a lack of coordination. Through close cooperation with the Ukrainian authorities, our forensic experts will map the existing action of national crime scene investigators in order to trace workflows and strengthen chain of custody with respect to hard evidence. Effective coordination and communication, identification of remains, ballistic analysis, storage and preservation of forensic evidence. In any case, this statement is quite concrete. That's not very common for the former prosecutors, and so it's certainly concrete, and you all need this kind of forensic activity. We will also be engaging with teams deployed by other states in Ukraine. So here's a reference to other states in order to comprehensively map existing activities and strengthen coordination. And my intention, the chief prosecutor's intention, is to ensure that this collaborative work is then continued through the consistent presence of my office on the ground, which of course is important, but is there deference? I mean, are the Ukrainians deferential to the OTP, or the French? Imagine, you cannot imagine this, or the Americans, that they will defer to a coordinating role of the OTP, which I think would be the only way. I mean, you need a coordination here, and you also then need a kind of decision who should investigate and prosecute what. That's actually the international criminal justice system. In a way, that's a kind of laboratory now. You know, we have so many states involved, we have NGOs involved, we have the ICC, we have a Human Rights Council investigative mechanism. What do these people do, you know? So it's like in Syria, where we needed this because there was no ICC jurisdiction. So maybe it's like this German word, too many cooks will spoil the, you know, the dish, you know? So perhaps you have in the end, you have a kind of counterproductive activity. But in any case, also Mr. Khan has achieved a lot in his first months, because maybe thanks, one could say a bit cynically, thanks to the invasion of Ukraine by Russia, because he got so much money now, and he used, of course, this new support, this kind of rebirth of the ICC at the international scene. You remember that the ICC was highly criticized before this whole Ukraine thing happened, and now it's a kind of star. Everybody likes the ICC, at least among the Western states, even United States. And he has received concrete support either by seconded national experts, 21 states, that was also in this statement, and also financial contributions. I know, for example, Germany has given a lot of money. So apart from the money which is pledged to be given to Ukraine, G7 money, there's also this criminal justice money, which, by the way, is, of course, creates another problems. Of course, who controls this influx of money? And you know, the Dutch Prime Minister, who is always very outspoken, say we cannot just give money, we need reforms, you know. So that's certainly an important point. But for the ICC, generally speaking, this situation has improved very much the visibility of the ICC, especially the visibility of the OTP, and has certainly improved the financial situation. Last year, the chief prosecutor was very much frustrated with a non-increase of the budget. And as you know, we have high inflation now, relatively high inflation. I'm not sure how it's in Poland. In Germany, you have almost 10%, which is very high for German accounts. And that means that even if you have an increase in budget, that's not a real increase. And therefore, there is certainly a positive development. Okay, that's for my part. Thank you very much. I'm looking forward to the discussion.
Włodku, mikrofon. Thank you very much, Professor Ambos. Is it possible that you just leave the presentation mode?
Yes, I'm trying to do it.
Then we can see each other.
Yes.
Oh, thank you so much. Thank you very much. Thank you for this presentation and all the remarks. You put many questions, and I hope that during the discussion we will try to answer this question. And certainly there are some more problems connected with not only the procedure, but I think also the potential basis for the activity of different agencies. You asked me if I know anything about the cooperation of the Polish prosecutors with the Ukrainian ones. That's another problem, because I think that most of this activity are treated as confidential. So certainly you inspired me perhaps just to take some steps using the national measure, let's say, to get some public information about this activity. But I'm afraid that it is also because of the Ukrainian party that they demanded to be more confidential. That's my suspicion only, but I'm afraid that we will not have many information on that now. The other thing is, I think you said about some chaos in all this procedures, agency taking steps, and all this activity. There is another actor, I would say, the national prosecutor, especially in Poland. We started our own national investigation on this because, as in many other countries, but especially in Poland, we have many of the witnesses that should be somehow asked now when it is still, let's say, in their memory, and all these witnesses should be somehow there must be a kind of registration of all what they say, and these steps must be taken immediately. Yes. So the other thing is, you mentioned that is also very interesting for me, that you mentioned the cooperation, or it was not your words, by Mr. Khan, the cooperation with the United States. And I think that it might be very important also from this point of view of the how to collect the evidence, because a lot of the criminal activity was taken in the cyberspace. And all what's connected with this cyberspace is telling the truth gathered somehow in some computer in the United States. So without the help, without the interception that is made there, it might be rather not so easy to get all these evidences. And this cooperation, how could the ICC cooperate with the United States, or even on the national level? That must be also fascinating. But I wouldn't take too much time. I will keep for me some minutes during our discussion. But now I open the discussion, and of course we are very interested also in the point of view, in the perspective of our Ukrainian friends, but some other participants of this meeting. So please just wave your hand, or just let me know who would like to be the first in the next minutes of our meeting. I do not see that moment.
Professor Robel,
okay, so let us continue, and the others perhaps.
No, I can invite Dr. El-Saidi, who is here, if he wants to say something. He worked for a long time at the International Criminal Court, so he's really an expert from the inside, and he's now working at Kosovo Specialist Chambers. Mohammed, if you want to say something just from your perspective.
Well, Professor Ambos, thank you for your insightful.
Please just turn on the mic, if it is possible, microphone. Just turn off, or someone.
I was thanking Professor Ambos for his interesting insights. And of course, I thank all of you just for having us here with you as well. There were some few remarks that I just wanted to raise with respect to what Professor Ambos was saying, because of course, Professor Ambos raised an interesting point regarding the Article 12, Paragraph 3 declarations vis-a-vis state party referrals, and what the prosecutor tried to kind of encourage or enhance state party referrals. And the main reason for that, and maybe Professor Ambos just said it quickly, is that the legal effects of lodging the declaration under Article 12, paragraph 3 is that it just provides, the court with jurisdiction, but it does not trigger the activities of the prosecutor. And that's why the prosecutor had one of two options, either to go to the pretrial chamber to get an authorization, which would have taken much more time to scrutinize the information and the information available, or of course to secure state party referrals. And as we've seen, of course, we managed to get a total of 43 referrals, which automatically led to triggering the immediate investigations on the part of the Office of the Prosecutor. So this was one little thing that I wanted just to clarify about what Judge Ambos and Professor Ambos said. If Professor Ambos, you would like me to highlight something particular, just please let me know, because I think you've covered different aspects with respect to the Ukraine situation and the ICC role.
Yeah, how do you see, I mean, as far as you can tell us under the confidentiality situation we are always in, you have very close contacts also to OTP, you are in The Hague. Generally, I mean, the whole performance of Mr. Khan since he took office, I mean, this, of course, is a context. I made this point that Ukraine certainly has boosted the ICC in a way, has brought it back in a way, if you want, like in football. It was a little bit on the left foot, and now it's back. So how do you see this generally, and how do you see the performance of Khan with regard to Ukraine?
Well, I would not say the performance of Prosecutor Khan with respect to Ukraine. Prosecutor Khan took a totally different stance than what Prosecutor Bensouda did. He's taking more of an active role, changing the dynamics of the office, meaning that you will see that he tried to adopt an exit strategy from a number of situations that were already under preliminary examinations and that has been pending for many years, including Colombia, which you, Professor, have worked on intensively. And also, instead, he just managed to exit from some situations, of course, to try to limit the resources of the court, but at the same time signing these bilateral cooperation agreements in order to make sure that, okay, still outside the legal framework, he may still have a dialogue with these states and ensure that things doesn't get out of control. So I think from that perspective, it's interesting. Of course, been active, of course, making the visits to some states to enhance certain kind of cooperation and division of labor in terms of investigations. And that's with respect to Ukraine. The interesting thing that here he's doing, of course, that he invited a number of states to provide some expertise with respect to the investigations. And yes, there is a drawback here that if you don't have proper coordination with respect to how these investigations are going to be carried out, of course, we will have an overlap in investigations because he needs, of course, to regulate who's going to do what. And but I think on that front, I think he's taking so far an interesting approach. It's very difficult to judge now whether his approach is or his strategy is effective or not. But from what I can see so far, I think they are going very well. He has now attached or just he kind of assigned actually the Ukrainian investigations to his immediate office with a particular team headed by someone like an SLO, senior advisor. And I think Ukraine is going to be one of those key investigations that the ICC have ever witnessed since its inception. And I think one of the major reasons for that is that this is for the very first time you have a collective support on part of more than 40 states. And it never happened. If you just go back and and look at the very first situations that was referred to the court, since the Uganda situation and the DRC, going through the different stages and years, passing through Afghanistan and other situations, you'll see that Ukraine is the most that gets the most political support from a considerable number of states of the international community. So that's why I'm optimistic about that.
Mm-hmm.
So thanks.
Thank you so much. Dr. Sharvan, Olena Sharvan is next.
Hello, everyone, and thank you for this gathering. This is amazing. And actually, all the points raised are very active and current. Unfortunately, I don't have any answers that I can share, but I raised my hand just to share some personal experience. Many of you may know that I'm Ukrainian by origin. I graduated from law school in Ukraine, did the PhD program in Poland, and ended up in the United States actively practicing litigation here. When war started, I was looking for the way to help and using my skills, and I came in contact with an organization called Physicians for Human Rights. So basically that organization is gathering evidence and helping to build cases in case of attacks on healthcare providers. And why I'm mentioning this, because we were trying to make contact with Ukrainian authorities and physicians organizations on site. And actually what I'm going to say is confirming the issues raised and why maybe we'll give some explanation why everything is kept secret, non-public, and why we have those issues that there are many people involved, but nobody knows who is involved in what task. Basically, what happened that because of the scale of invasion and scale of violations and how many people died in different places and cases are spread and people are fleeing, it's very difficult to take control over witnesses, over evidence, and over people involved in those actions. And what we learned that Ukrainian government and prosecutors, they do not want to discriminate. They appreciate all the help they get from other states and NGOs, but with a number of people involved and contacts, they are afraid simply that they will lose control. And they're afraid that this will create an issue in future cases and trials. Because if we have the same witnesses interviewed by different organizations, prosecutors from different states, NGOs, those interviews, they create statements, and people expressions and statements, they differ. And then other side will use those differences to challenge the account, what happened. So at this point, they don't want to reject any help, but they just want to try and start from the small and create a small group of people involved. And then when they have a plan and they have a division of roles, they will start inviting other people to be involved. Also, they're afraid of information being shared and leaked to other sources. Unfortunately, it happened many times. You know, in US, it recently happened that a draft of court decision, Supreme Court decision was leaked. So this is a very real threat, and they're concerned of that. What happens, so they still invite people to help, but they ask to let them do their work together with ICC, and then additional help will be welcomed. With Poland, it was from the very beginning, and Lithuania of their contact, and maybe those are people, their contacts that they have been with them before the war, and this is the starting point only. Also, another issue that was raised is why Ukraine hasn't ratified ICC statute, Rome statute as of right now. Actually, that issue was raised by us in UN and other places when Crimea was annexed, and Ukraine first time asked for ICC's intervention. And the answer is political. basically because different forces were against and concerned, and there was not enough political will to do that. This is from the account I have from different stakeholders. Why it's not done right now, it's again, now situation is different. Now there is political will, but because of the state of emergency and the active war, they are not so sure what consequences it will have for future. I don't know, this does not answer the question, but those are the concerns that I have heard so far. And another point just for us not to miss on my list is just like the issue of special tribunal. It was actually, I was part of the group, we prepared a report. Actually, with this occasion, I brought it up. It's like human rights violations in Crimea. In that report, when we were presenting it all over the Europe and in US, we recommended to create special tribunal. And at that time, it was in 2015 in fall, and people ask us like, why do you need special tribunal? You have International Court of Justice and you have ICC for different aspects and different violations. And the answer and the idea was that ICC is not maybe enough funded or operational, because if you go on their website, since their creation in 1950, if I'm correct, only a few cases were prosecuted and brought to trial. And with the scale of violations and human lives lost in Ukraine since 2014, the consensus was that ICC is simply not capable of prosecuting all those cases. And because for ICC, like UN will have to be involved and permanent members, and that would be challenging. That actually may have changed at this point with all the referrals that ICC received to investigate Ukrainian cases. But me personally, I still believe that special tribunal is a good idea because of the number of people that need to be prosecuted. There is also an opinion that regular soldiers or low-rank military officers can be prosecuted by Ukrainian government on site if they are arrested, and ICC can take care of higher level officials. That's also true, but life is long, and we do not know how the international relationship will be in future. So the idea was actually to have this international tribunal with international experts and international involvement. So the good deed is there for maybe forever or for many years. So with international involvement and status of international court, like it was done for Yugoslavia, that would be much more difficult to challenge the decision made, because maybe there will be change in government in Ukraine, God forbid, like to different side, and then those people will be released, or a decision of Ukrainian government will be nullified. With international involvement, those prosecutions, they'll be more likely to be set in stone. This is actually an idea, and I'm very curious to hear what you think about that. Thank you.
Thank you so much, Olena. That was also my question. I see, Mr. Zaidi, I will give you the floor. That was also my reflection that we are talking very much about the special tribunal. Does it not, in the same time, undermine a little bit the whole idea, the whole concept of activity of ICC and also the prosecutor of ICC in the case now? Because it seems to be like we distance ourselves a little bit from the effectivity of ICC now in Ukraine, but still we do not have a special tribunal. And in that way, we are staying somewhere in between, not being effective as much as it might be possible. Mr. Mohammed El-Zaidi.
Actually, my question is correlated to or interrelated to what you raised, Professor. You know, Olena, I value very much your comments, and they're very useful. But when it comes to the ICC, I just want to ask you, what do you see that the ICC cannot do and an international tribunal can do apart from the issue of the crime of aggression? And why don't you see that, you know, that the ICC could still enter into kind of an arrangement for burden sharing of responsibilities between Ukraine and the ICC? They take part and they deal with a number of incidents and certain high-level perpetrators, perhaps, or those most responsible, and the rest would be for the Ukrainians. Why do you see that special tribunal would do that better than the ICC?
Yeah, maybe I can just follow up on Mohamed's point, which I largely share, but just two other aspects on this specific issue of a special tribunal, which certainly has this reason in the lack of jurisdiction for the crime of aggression, given that we will never get a vote of the Security Council, and we have a very complicated regime for jurisdiction.
Yeah.
But we have discussed this a lot here in Germany, and there is practically no support for this idea because there are so many practical questions involved, not just legal issues, but also practical ways. So who will pay for this? The first question. So I participate in the drafting of 98 of the Rome Statute, part of the German delegation, and one of the reasons to create the ICC was exactly to avoid further ad hoc tribunals or whatever kind of special tribunals. And then basically we say, okay, we put our money into the ICC. It's not a lot of money anyway. And I think it's very difficult to find political support among the taxpayers for more money for international criminal justice, kind of special tribunals, if you have one called ICC. And the other issue, which does not seem to be answered by the people like Philip Sands and others, some politicians who want this, is on what legal basis you want to create it. I mean, if Ukraine creates a tribunal with other states, that from the start is a non-starter, because then the Russians certainly will say, and not just the Russians, that's an anti-Russian tribunal. That's an issue. And you will not get, of course, a Security Council resolution to create a tribunal like we did with the Yugoslav tribunal, because the Russians will not go for it and the Chinese will not go for it. So in the end, the only thing you can do is a kind of Sierra Leone situation. You have a country which has a bilateral agreement which says, we want this tribunal, we give you jurisdiction, i.e. Ukraine, and then you have supporting countries, which will be less countries than even the countries which now support the defensive war of Ukraine. And then in the end, you don't even will have a legitimate tribunal, and especially not in terms of the Russian propaganda. We have to be very careful here. That was my concern when I started to say we have to look much more critical. I say this here, I said it today, we'll say it on Monday in the interview, to look at the Ukrainian investigations. We cannot accept double standards here. If there are war crimes committed by Ukraine, if they mistreat the prisoners of war, we have to force Ukraine, or Germany or others have to investigate these crimes. Otherwise, we will feed Russian propaganda. We will feed Russian propaganda, and also we should be aware that we as West are not at all credible. We have violated international law in invading Iraq. We have, in many different situations, acted without Security Council resolution, and therefore we must be very careful. And now speaking about Kosovo, that's a whole nother story. I'm at this tribunal, but I shouldn't say something here. But Kosovo, of course, is a main argument of Putin as to Eastern Ukraine, and that was an argument created by the West. It was an argument created by the so-called humanitarian intervention in the Yugoslav war by the NATO without any Security Council resolution, and an argument with the independence of Kosovo. Now, if you accept the independence of Kosovo, then you accept the independence of the Basque Country in Spain, and then you may accept any independence of a region which makes the argument of being attacked by the other part. That's a genocide argument, the alleged genocide argument, the false argument of the Russian regime, of course. But So I think we have to be very careful here. And instead of, and here I agree with Professor Robel, instead of undermining what is anyway a weak organization, namely the ICC, we should rather try to focus and help the ICC. And so I still don't see the case for such a special tribunal, Olena, but thanks a lot. Maybe you can convince us.
Mm. I would like to beg you, Olena, a little bit. Because, you know, I can understand the Ukrainian point of view, because it is the experience with ineffectiveness of the ICC after 2014. And in many, many other cases, yes. We know that the whole procedure was so long without any clear effect. So the public opinion has no information about what's going on after 2014 in Ukraine. So now, you know, you can also use the argument that the ICC is there, that the prosecutor is there, just to stop any kind of effective activity. Because ICC will do it, but when, how, you know? I thank you, Professor Ambos, for the great spot of information about the activity of the prosecutor Khan. It gives us a little bit of optimism, maybe, a little bit. I think that the situation is more complicated than we think, because at the very beginning, I was in contact with many judges of the Supreme Court of Ukraine. And it seems to be that the whole system is falling down. The judges went to Lviv, they were looking for some security, let's say, measures rather than they are ready to judge anything, yes. But now we are in a totally different situation. The legal system of Ukraine seems to be working, seems to be active, and seems to be effective. We are hearing about the first procedures that are there. Yes. And, you know, and in that situation, I can even more understand that from the Ukrainian point of view, I'm thinking also about the public opinion in Ukrainian, yes, that it is our task to give the justice. If not, it should be made by us, maybe by establishing the new tribunal. But, you know, the activity ICC, it looks like, I don't know, that's the question to our Ukrainian friends, but from my perspective, as I would experience it in Poland, it looks like I do not believe in my own state, yes? And the state is active now, yes? There is government, there is an active president, there is the Supreme Court, once again, very active now. As far as I know, there are parliamentary procedure about the new penal code in Ukraine to be accepted, and it hasn't been stopped. You know, it is even more complicated. But sorry, Olena, maybe you could be a better advocate of your ideas than me.
If I may, it's actually what I was going to say, because the issue was efficiency and how fast. And when I speak with people, regular people, because they are the ones whose interest we have to represent and whose request or need in justice we have to satisfy. And when I'm talking about ICC and those who can do that and educated enough, they go on the website, it's like say, but whom did they prosecute in past? They actually do not see the results. And the question was how effective ICC can be in Ukraine. And as Professor Rubel said, like request was submitted after Revolution of Dignity, when over 100 people were slaughtered on streets by Russian mercenaries. And there was no even formal announcement of investigation. So I would say, yes, give ICC the chance, but Ukrainian government also has to see and justify what they're doing in eyes of the citizens. And in this way, even if special tribunal is not created, I support the idea about bringing this conversation up. And if the idea of special tribunal will boost ICC and we will see some actual indictments or arrests took place, so maybe the idea of special tribunal will be moot. But I would definitely not dismiss it at this point. And even if it's not like regular international tribunal, but some international involvement with respect to Ukrainian prosecutions and investigations actually done. Because, for example, yesterday I was watching trial of a Russian soldier who shot the man on a bicycle in Bucha. So those trials are actually happening, and they are legit trials. But because of a propaganda that was mentioned before, international involvement and securing evidence and also financing of those investigations, so those trials are faster and more efficient, is much more welcomed. And I know that it did not alleviate any of the concerns, but this is the reality, and situation is new, and the scale is much bigger because it's active war, situation is changing, and we have to be flexible. So I would vote that everything should be on the table.
Yeah, that's very interesting. I will give you the floor, Dominic, in a moment. But it seems to be that we are now in a core problem of the substantial criminal law. From whom do I demand or expect the justice? From the international tribunal or national tribunal, something that I created myself? Because I can understand that the international community would have more confidence to ICC. That's what you, Professor Ambos, said, that there are perhaps also the crimes committed by the Ukrainian part. But now that's what is for us the most important, is the aggression and the war crimes committed by Russian. I don't know, it's the moment of truth for the whole international system. Would it be effective or not? And the whole system developed step by step by so many years, yes? And now I'm totally agree with Mohammed that it is maybe the most important case before ICC, and that it will be a test for the whole institution. Dominic Zając.
Okay, two remarks. First, I think that telling about ICC as a court who is acting not in a rush is, of course, it is true, but it is also very idealistic. Because when we are looking at the ICTY, for example, the situation was the same. I think that it is a problem of the international criminal law, not about of ICC. And we can create the new tribunal, and the problem will be the same. And the problem, because the problem is not ICC, the problem is the idea of the international responsibility. And the second thing, to punish, to hold the responsibility all of the soldiers who killed, for example, this man on the bicycle. Ukrainians don't need a special tribunal. They have courts, they have usual state courts, yeah? They can do it because of the principle of territoriality, because of the all other principles. They don't need a new tribunal. And the third thing is that there is some cases which can't be judged by national tribunals because of immunities. And this is the problem of the Putin, for example. And ICC has a much better instruments to hold the responsibility such kind of people. And this instrument is not applicable in the field of the Ukrainian law because of the political immunities. Yeah. ICC can enforce some kind of arrest warrant, try to prosecute him around the world, and Ukraine probably cannot do it. So there is a point where ICC is probably maybe better than national criminal system.
Okay. Thank you, Dominic. Dr. Iwański, Mikołaj Iwański. Sorry, Professor Ambos, just after Dr. Iwański, and yes. Would you like to comment now? Professor Ambos?
I just had one issue. The immunity issue. Immunity issue is very important in our context, and this has to do with the creation of a special tribunal, how we will create such a tribunal. If we, for example, would create such a tribunal on the basis of the consent of Ukraine, i.e. Ukraine says, let us create this tribunal. We give you jurisdiction because I have territorial jurisdiction, being Ukraine. Then I think it's not possible to remove immunities. We had this discussion for 30 years. I mean, we can only remove immunities either by the Security Council creation of ICTY, for example, ICTR, then we have a non-immunity rule before this tribunal, or in a situation of a multilateral treaty, but it's of course much weaker, internationally speaking, under the ICC regime. But if we create a tribunal only on the basis of a consent, then of course this country which creates and delegates, because Ukraine will be the most important player in this context, may of course renounce immunity for their own officials, but not for the Russians. I mean, that's a clear-cut situation of horizontal immunity, and that brings us to the very nitty-gritty issue of creation, where I don't see any convincing argument in the Chatham House discussion. I mean, the rest is politics. I mean, we can discuss about politics, and I get your point, Olena and Vladimirovich, about the necessity from the Ukrainian perspective. But give me a legal creation. Let's say, a legal creation which creates a tribunal which is beyond any legal dispute, and which will be accepted by international lawyers as such. We already had a discussion by international lawyers in the blogs about this problem of how to create this tribunal. The second point refers to I put you in the chat this paper by Sergei Masol, who is actually he is Ukrainian, I think. He's actually now at Cologne and Humboldt scholar. And this is a very interesting paper. It's about this issue of ICC ratification, which we lost sight of now, but Olena made a point, that's politics. But it's much more than politics, it seems, because according to this article, and the guy is of course an expert because he studied all the Ukrainian positions on this, and there is a lot of confusion in Ukraine. For example, even mixing up ICJ and ICC and mixing up Article 12.3 with a normal jurisdiction regime. But then in the end, and that would be interesting for me to hear, maybe later, Olena, or from someone in the round, if you have time to read this paper, because he in the end supports Ukraine in not ratifying, So that's the interesting point in this paper. The guy is criticizing the level of discussion in Ukraine all the time. He says these politicians who are against this, they don't know what they are talking about. He quotes a lot in Ukrainian in the footnotes, but then in the end, he says strategically, it's better not to ratify and to go on with 12.3 because we can withdraw the 12.3 declaration. Here's my question also to Mohammed, and I already sent it around, Mohammed. Maybe we can talk about it later. Maybe that's too much for this meeting, but what happens if you withdraw a 12.3 declaration? I mean, we never had this situation, but you're an expert on this. Can you do it first? I think you can, because you can also withdraw from the statute, but is it retroactive? If Ukraine would withdraw the 12.3 declaration, what would in terms of jurisdiction happen?
I think with respect to 12.3 declaration, I think it's a bit different than, once the jurisdiction of the court has been triggered, just to put it in more simple terms, by analogy to the practice of the International Court of Justice, you cannot withdraw. So for 12.3 declarations, my own personal opinion is that you may withdraw the declaration as long as the prosecutor has not started his investigations. Once that took place, you cannot take back the investigations are stopped. It's the same like what you have with respect to state parties who decide to withdraw from the statute. The fact that the state takes that decision does not affect the ongoing investigations that are carried out by the court. So it's mutatis mutandis. It's the same. There's the same legal effect.
Well, yeah, if this is true, I think it's convincing. Then you reject Masol's main argument in the paper, because he basically makes this as a main argument not to ratify. He says that we are much more flexible under the 12.3 regime because Ukraine tomorrow says we will withdraw, but it will not have effect on the ongoing investigation. It cannot. That would, you know, like in national procedure law, we have similar situations. I mean, there is a certain moment in time in the procedure where things are set, and it cannot be in the hands. Actually, Ukraine left this area of, it gave the ICC this jurisdiction, and it can, of course, for the future take it away. I mean, if it tomorrow says we withdraw the declaration, that will have an effect pro futuro, but it cannot have an retroactive effect. So that is an important point, and this is not discussed in the paper, but I really recommend you, for those who are interested in Ukraine, read this paper, and then maybe you can come back via email, we can communicate. What do you think?
Mm-hmm. Thank you. Now, Dr. Iwański, then Professor Skąpska. Or you would like just to intervene in Olena, something?
Yeah, just quickly, because I missed one point when I mentioned about ratification of Rome Statute. There's also internal legal discussion within Ukraine, and Professor Abramos actually reminded me about that by sending the article. Since 2001, there was a discussion, even some claims were sent by MPs to Constitutional Court with respect to ratification of a Rome Statute, whether it requires change to Ukrainian constitution. And actually recently in 2020, I believe, don't quote me on dates, the changes that would alleviate some of the legal arguments against ratification of Rome Statute have been made to Ukrainian constitution. So this is just one point. Also, another that I just remind point about ratification of Rome Statute. For some reason, there was also a discussion raised during one of our presentations in European Parliament that Ukrainian government may be afraid that that ratification will be used against Ukraine by Russia itself. Because Russia will not be, Russia is not subject to jurisdiction, but since Ukraine is, that may be used as a leverage. I don't agree with that point, but since we are discussing this, I decided to raise that issue.
Thank you, Elena. Now, Mikołaj.
Hello. I have only one short remark about this special tribunal or criminal justice on a national level by Ukrainian courts. I have certain doubts, maybe not of a legal nature, but more of the political nature. I would like to share. I think that especially during the time of war, it's a little bit uncautious in a part of Ukraine to start formal criminal proceedings against Russian soldiers. We have a time of war. We have two parties, Ukraine and Russia. Of course, we are wholeheartedly in support of the Ukrainian, but we must see it. Try to look at it objectively and look at that, as Professor Ambos stated, the international community is not as unified as we in the West think. There are many countries that are buying a little bit of Russian propaganda. So I would be afraid that prompting now in the time of war, which is also very emotional time, launching these criminal proceedings gives a little bit of legitimization for the Russia to create its own special tribunal or its own criminal proceedings, for example, against Ukrainian soldiers captured in Mariupol or in other areas of Ukraine. And they may say, look, Ukraine is doing, we are doing exactly the same thing as Ukraine is doing. So I think that from that point of view, independent, previously established, well-known, well-recognized in the international community, ICC is much better. So that's only my little remark. Thank you.
If I may quickly what Mikołaj said, it's actually to the point, and I will not be able to quote, but it's the same as our president said, that the existing laws and community, it does not work. So we have to come up with new solutions. And it should not deter us that Russia will do the same and challenge, because at the end of the day, it's about who is with whom and who supports who. So the fact that I strongly disagree that the fact that Russia can create their own special court should not deter us from doing justice and employing new measures, because Ukraine was not accepted to EU for many reasons and NATO for many reasons, but also because of we didn't want to provoke Russia. And nobody provoked Russia for 8 years, and they still did what they did and what they wanted from the very beginning. So there is never a guarantee what will happen. But if this mechanism of special court will help us bring justice and also secure some retributions, because remember, if we create the special court, it has to be based, as Professor Abramo said, it has to be based on international agreement. And it's not only about the investigation and trials themselves, but it's also about the sentence and execution of the judgment and potential retribution. For example, if US and Ukraine has this agreement that they participate in international tribunal, and then that would mean that they recognize the sentence and the judgment, that will give US, for example, tools to use all the arrested assets to pay retributions to the families and victims.
That's what you said resembles me a little bit our national discussion, how to react on violation of the rule of law by the legislator and the government in the way that the rule of law accepts, how to be constitutional in the time of unconstitutionality. So it looks like you would like to be very loyal to the international law principle with someone who is violating it so immensely. And also there's a nuke state, it's another thing, yes? So the main player in the world stage, yes? Professor Skopska. Potrzebny mikrofon, prosimy o włączenie.
Okay, I think that, okay. So firstly, I would like to add some few words to the previous discussion on this necessity of proceedings against Russian soldiers committing these crimes on the territory of Ukraine. So I think that Russians will do whatever they like independently, whether there is a court established in the Ukraine or not. And on the other hand, this example of the criminal proceedings, which are very, let's say, going on in this case, in the trial of this one soldier, set a good example to follow. So I think that in this case, this is a great symbolic value exactly of that trial, and that symbolic value is also of a very big importance for both parties. I think that Russians will not take that into consideration, but other involved governments and stakeholders in this war will see the examples of the Ukrainian judges and the Ukrainian law, which is applied according to some standards and principles. And I think that that kind of symbolic value is not to be underestimated in this case. So that is my comment on this trial, which we have observed, look at nowadays. But I have another question to Olina. As a matter of fact, considering this, let's say, this special commission or a special court or whatever we would like to establish in order to make it more efficient, I this is my question, whether the Ukrainian government has considered another solution which was already applied in Latin America or in Africa, like truth commissions. This is some special body which is not expected to punish, but it is expected to explore the truth. And that could be organized in any way, because it is just an quite new invention of, let's say, last 40 years, something like that. But nevertheless, it gives some instrument to all engaged parties, especially to the victim, to investigate the truth. And in this case, to make some justice to the society, to the victim, as a matter of fact, who in this way will have some established knowledge about the scope and range of atrocities which were committed on its territory. So that is my question, whether this kind of ingenious institutions were already considered or could be considered by the Ukrainian government. So that is my question. Thank you.
Honestly, I don't know, because I'm not with the government in context of sporadic. I invited for today's webinar a representative of Ukrainian embassy in US. Maybe he's watching us, but I'm happy that we have this webinar recorded, so I will make sure that they receive it, because a lot of very valuable points were raised that actually government has to consider. Maybe they are considering, but also the arguments that were presented may be helpful for them. So definitely I will pass the information and the question.
Hey, I will follow the question of Professor Skomska. We are going to ask Professor Ambos to comment a little bit of anybody willing this, because it seems to be that the dynamic of international criminal responsibility somehow immune from politics. Once the investigation has been instituted in the ICC, there's a trial, it couldn't be politically stopped. Otherwise, we will destroy the whole system of the international responsibility. On the national level, it is possible to find some political solution when the law is not, let's say, enough effective, but we would like just to avoid very harsh measures of the criminal responsibility. You know, it is connected with some other question. Really, Professor Ambos, can you imagine a trial against Putin, an acting president of the nuclear states, in ICC? Or perhaps we are talking about a kind of a myth, about a kind of an idea that we can dream of, but to build the whole system on this idea, it might be a little bit, you know, disappointing and frustrating in the end.
Well, I would like to make some comments on previous points before I give you my view. First of all, as you know, I have worked for a long time in Latin America, actually for 30 years now. I'm looking younger than I am, so you won't believe it. And especially on this issue of transitional justice, and also we had a big project in the Max Planck when I worked there, and including in the Eastern European countries. So this whole alternative mechanisms, transitional justice, including truth commission, was always designed for non-international armed conflicts. And we should not forget that we are here speaking of an international armed conflict. It's a country invading another country. That's a war of aggression, okay? And I think we should be very careful, and a little bit the last 20 minutes of this debate, for me personally, we're too much at advocacy. I mean, like an NGO debate. We are an academic, I think we are here in an academic forum, and that means we have to try to be very objective. I understand that someone from Ukraine, I have myself friends from Ukraine, maybe are more partial. Of course, it's your country that is invaded, but from a more legal perspective and more academic perspective, we have to try to be more neutral and more academic. And therefore, I think the whole idea of a truth commission does not work in such a context. It would again be a commission set up by one party to the conflict, don't forget it. And the other party would never accept this narrative. You need an independent arbiter here. That's why Ukraine rightly went to the International Court of Justice and got a great decision with only 2 judges, namely the Russian judge and the Chinese judge, voting against. Read the provisional measures. The ICJ was going beyond the Ukrainian request, namely saying basically to Russia, stop this war. That was a great measure. So Ukraine played very well this card. Also, Ukraine used the European Court of Human Rights. That's what we have to use. We have to use international institutions which are credible and not create national institutions which always will be seen as created by one party to the conflict. So even if we 95% in Europe in favor of Ukraine, that will not change this narrative in the world. Also, I'm not so sure that this national process going on, the process of this soldier, is so convincing. Here in Germany, it's very critically looked at, because the question is, what is justice? What justice do we talk about here? What kind of justice are we actually trying to achieve? If it's not about fast-track justice, it's not about establishing a special tribunal which in a very fast manner without defense rights prosecutes and convicts Russian war criminals, that cannot be our justice. What we want is fair justice. We want tribunals, either national or international, which of course respect the rights of the defendants, which of course, and that means time. We in the Kosovo Specialist Chambers, we still have people in the room here. We are very quick, but we are a fully fair trial tribunal, and we have a lot of problems in terms of the environment in Kosovo, anti-environment against us and Russians, etc. But I think we cannot compromise on fair trial. We cannot compromise on impartiality, independence, and therefore it's a question of justice. I mean, the key word is just and justice. It's not about this kind of what we saw in Romania after the end of the Warsaw Pact when Ceausescu was killed. You know, maybe that's for some people nice that someone like Ceausescu is killed, or Osama bin Laden for this matter, but that's not justice. That's just extrajudicial killing. That's not what I want if I speak of criminal justice. I want fair trials, and fair trials need time. So you cannot guarantee that a special tribunal will be quicker than the ICC, or even quicker than decentralized prosecutions by France, by Germany, by England, by Spain, or by Ukraine. At any rate, there could be no compromise for justice. As to the perspective, I really agree with the colleague, with Mikolaj, if I can use your first name, which is either Ivansky, Mikolaj, because we should not forget the international perspective here. That's why I showed you this voting situation in the General Assembly. You know, I gave this talk to Latin Americans, and you know, they will not support our argument. Is not just that they believe the Russian propaganda. That's not so easy. They have their experience, and that's a bad experience with United States. United States is the country which in Latin America is considered as a country which topples governments if it likes. You know, it started in Guatemala, it did it in Chile with Salvador Allende. It intervenes when it likes. So United States is not at all credible for the Latin Americans. So in Latin America, you face another different reality. From Mexico to Argentina, you have to tell them, but here we have Russia committing a war of aggression. So it's very hard, and they will tell you, okay, that's okay, but United States did the same with us. So you are in a difficult situation, and we have to speak globally. We have to think globally, and that's why when I started this talk, I made this reference to Poland and Germany. I think in Poland, maybe it's worse than in Germany. In Germany, it's very difficult to be critical of this whole situation, but in Poland, it may be worse because the Polish support is so 100%, so 150% to Ukraine that maybe there is not even a public debate on the fallbacks of this. So I think what we need is really we need proper investigations, we need fair trials, and then of course we need accountability. And my position in the article which Dominik translated into Polish exactly is why I prefer the ICC. The reason is that the only court which can ever if at all, maybe the ICC cannot do it either, can ever do justice to this kind of most responsible, like Mr. Putin, would be the ICC. And at any rate, I think there can be no compromise to fairness. And in this sense, I would be very cautious. And we, the West, and the Germans especially, should be very self-critical of our position with regard to this. For example, I made this point about the chits when we started this discussion. I mean, you know, imagine this situation. If we supply Ukraine with weapons, we are doing this now. We train Ukrainian soldiers in Germany. We now send every weapon you can imagine. Maybe only the Americans and British send more weapons and bigger weapons. But if Ukraine is not part of the ICC and therefore expresses a certain distrust in the ICC and in a way also expresses a certain, let's say, a disinclination to accept investigation which are independent, also against Ukrainian soldiers, then we will be part of this game. This will come back to us. If we tomorrow find, I had today a conversation with a colleague about this here, if we tomorrow find a kind of butcher of Ukraine, I don't think that we will find it. It will not be that terrible, but we will certainly, we already know, and there will be war crimes, mistreatment of prisoners already. And then it will fall back on us, because then we will be asked, so why did you blindly support Ukraine? Blindly support without making reservations, like the Prime Minister of Netherlands, for example, or without making, in this, he spoke of reforms, but for criminal justice, that means we have to ask Ukraine to do their job, and that is to ensure justice for crimes committed on the territory of Ukraine, committed on the territory by both parties. So neutrality is the key issue here. It's like the ICRC, the International Committee of the Red Cross, who had to justify, Mr. Mauer had to justify himself that he met Putin. Of course, he has to meet Putin. The ICRC is a neutral organization. The ICRC is not part of the conflict. The neutrality is a strength of the ICRC, and neutrality is a strength of the international criminal justice. Perhaps our president, Mr. Trendavilova, which I see now in the photo, which gives us the honor to be part of this debate. Maybe she can say something with much more authority than myself, much more experience. She was judge at the International Criminal Court. She is now the president of the Kosovo Specialist Chambers. How is her view on this? If you want, Ekaterina, I'm not sure if you want to get involved here, but please, it would be an honor to hear your views.
Well, thank you. Thank you very much. Actually, I was following this very, very interesting discussion since the very first moment, but I was hidden, so I decided to disclose my presence here. And first of all, to say that it is a very, very interesting discussion, very useful. I was invited by Judge Ambos, who is a dear colleague, and I have known him since the time I was a judge at the ICC. Well, of course, there is a lot of passion, but also there is in our exchanges and elsewhere. There are a lot of events, a lot of meetings. And of course, I do agree that we have to leave aside to the extent possible, of course, because it's very difficult for people who have suffered immensely. And we are all suffering, although not being exactly on the spot and face-to-face witnessing the atrocities committed in Ukraine. But I would join those participants that are still willing to focus all the expectations to the ICC. Because Olina, I understand she's very passionate. I fully support you. I can imagine that maybe if I were you, I would have been willing. I would forget all my legal education if I meet someone of the masterminds of this whole war and aggression over the Ukrainian territory. Who knows what I would have done. But this doesn't work. We have really to, as Justice Robinson, I think, was saying in the Nuremberg trial, when there was a willingness just to kill the masterminds of the Nazi time, he was saying we have to be very careful because the bitter chalice thereafter will come to us. So, and this was the wise way to go ahead. This idea about setting up a special tribunal, and here there is much more inclination towards setting up a tribunal for the crime of aggression, because it is true, as Georg was explaining, that the regime that was adopted in Kampala with the definition of the crime of aggression is very, very complicated. And that's why the ICC prosecutor, Karim Khan, made a statement that he's investigating crimes against humanity and mainly war crimes. This is, in my view, at least at this point in time, not a very good idea, because it was already said this requires time, requires a lot of resources. And for example, Alina, you were saying that it may be possible, being focused only on this situation, to expedite proceedings and also to have arrests. Here I have serious doubts. This will be exactly the same as will be the picture at the ICC if the prosecutor will seize the pretrial chamber and will successfully be requesting the issuance of warrants of arrest. The ICC doesn't have, and the tribunal wouldn't have, enforcement police officers, and it will be extremely difficult, in my view, impossible at this point in time to arrest those who really are at the top of this vicious plan to invade the territory of another country. Here, I'm very, very much in agreement with all of you, in particular, the concerns of Olina about expeditiousness before the ICC. It is not because, and I'm not defensive here, but it is true that the realities are ongoing conflicts, investigation, arrest warrants that were issued, and thereafter they just are frozen, waiting for example, either those for whom there are arrest warrants to surrender because they fear the specific circumstances in the country where they are just changing the different guerrilla militia and so on and so forth, or it happens very rarely that the suspects could be apprehended and brought to the ICC. In my view, there is a danger if the prosecutor, first of all, I'm satisfied so far with the prosecutor because he made a very clear statement, hoping that this will be de facto the nature of his investigation, that the investigation will be objectively investigating both sides or any other side, because we know that there are mercenaries also from Chechnya and from other from Syria also. Mr. Putin was considering to bring mercenaries to the field. It is very, very, I'm very much concerned that 43 states already expressed their willingness by making this collective referral. States are willing to investigate, and they have to support the office of the prosecutor, because we have this office, it has its established practices. Now the new prosecutor is changing some policies, rightly so, based on the shortcomings of previous practices. But what I told during one event last Friday here, organized by the French embassy on the crime of genocide and other grave crimes, I told Mr. Khan, with whom I was sitting on the same panel, that he has to have a very, very clear strategy. And he has to be the focal point for all those states who would like, or not only states, NGOs, because pursuant to Article 15, paragraph 3 of the Rome Statute, the prosecutor may receive evidence, as in any domestic system, but the prosecutor can also receive information from NGOs, from individuals, of course, from reliable sources. That is what the Rome Statute says. But the prosecutor has to establish a methodology and has to supply all those who would like to support his investigation with this methodology. Meaning what? Of course, every state can investigate Ukraine because crimes were committed on its territory. And at the beginning of June, I was asked to appear before Zoom, of course, before Ukrainian prosecutors and to speak about them, about the requisite elements of the war crimes and crimes against humanity as reflected in the Rome Statute, because it will be very useful if being guided by the elements that have to be proven by evidence, that states and anyone else who would like to support the prosecutor provides evidence related to these requisite elements. Also, the prosecutor has to guide all those who would like to support him. For example, normally at the ICC, the very thin element of the crimes against humanity was the policy element, pursuant to Article 7, paragraph 2 of the Rome Statute. And the prosecutor, having a good methodology, receiving evidence that is related to this element or to that element as the Rome Statute requires and the rules of procedure and evidence, analyzing the evidence will identify as of the early stage of his investigation where there are lacunas, and will go back and say, stop, for example, if we speak about crimes against humanity, providing me evidence about the contextual element, widespread systematic attack against the civilian population, but I need more evidence about the policy element. Then it is also very important, and I will stop because I can speak about the ICC forever, and I wouldn't like to be boring. It is also very important to know what is the first task that the prosecutor is facing right now. And here, I agree to a certain extent with my very, very esteemed colleague, Judge Ambos, because, for example, in Kenya, the Walkie Commission was providing to us its findings. Of course, this is not evidence that has the potential of proving the charges, but it is for the stage where the prosecutor is right now, together with evidence that has high probability value. Of course, the prosecutor could trigger proceedings before the pretrial chamber for the purposes of issuing arrest warrant. So it is very important for the prosecutor in this methodology that I just in passing suggested to him, because we have decided we have agreed to meet and to discuss more in depth, just to be very, very carefully considering for the different stages of his future cases or his investigation right now, what type of evidence and what amount of evidence. Because if the prosecutor leaves it only to states, NGOs, individuals to provide evidence, everyone, whatever, in isolation and without realizing what are the needs of the prosecutor based on where the prosecutor stands at this point in time, then we are risking the office of the prosecutor to be flooded by voluminous pieces of information, evidence, and so on. And then, of course, Olina is going to be 100% right, because the pretrial chamber has the duty to go through every single piece of information, evidence that it has received. So there are a number of different issues that I believe the prosecutor at the ICC has to very clearly see from above, to see what is necessary to establish meticulously a very, very clear methodology, and thereafter to be guiding and to be working in cooperation with everyone who would like to support him. So sorry very much, that's why I was hidden, because I wanted to listen, knowing that if I take the floor, it will be difficult to stop. So thank you.
Mr. Prof, your microphone.
That's my fault now. Thank you, President Trendofilova, for your comment and that you joined us tonight. Thank you so much. We have so much to think of, but Professor Skomska, I don't know, you wanted to comment something, because I saw your hand in a moment. No, there is no. If anybody else is willing to take floor or to comment on things or put some more question, I don't see anybody. We are already we was already discussing 2 hours. Professor Ambos, it's our tradition that the last voice is for the speaker. So if you would like to answer still some our doubt a little bit or convince us still, so the floor is yours.
I think Ms. Novikova raises.
Oh
raised
yes,
her hand
still Dr.
now.
Novikova. Yes, certainly. Pani doktor Nowikowa z Charkowa i ona mnie prosił wtedy o angielski, dobrze?
Drodzy kolegi, bardzo dziękuję. Ja będę mówić po polsku, bo tak lepiej niż po angielsku, ale ja chciałam w ogóle podziękować wszystkim uczestnikom za ciekawe poglądy na ewentualne rozwiązanie problemów України związanych з агресією.
Професор Новіка, я перепрошую, я буду перекладати, то ви говоріть короткими реченнями, щоб я переклала на англійську.
I pani doktor, może pani po ukraińsku w tej sytuacji, bo wszyscy zrozumiemy.
Ну, chciałam po polsku, jeśli to możliwe. Można?
Good afternoon, everyone. Thank you for this gathering, and I will continue translating.
Nie jestem ekspertem z międzynarodowego prawa, ale chciałam jednocześnie wyrazić swoje poglądy na temat rzeczywistych problemów w systemie prawnym Ukrainy, który potrzebuje pomocy cywilizowanego świata.
Nie jestem I'm not an expert in international law, but I would like to share some views with respect to current and pressing issues in Ukraine.
Przedstawię dwa główne problemy. Po pierwsze, na Ukrainie brakuje odpowiedniej wiedzy i ekspertyzy do oceny prawnej zbrodni wojennych.
There are two main issues. First is that in Ukraine there is no enough knowledge and expertise with respect to how to evaluate violations of law in times of war.
Po drugie, wreszcie mówi się o uznaniu działań Rosji przeciwko Ukrainie za ludobójstwo, ale niestety nikt nie może teraz rozwiązać sporu między Ukrainą i Rosją. Co więcej, nie mamy jasnego zrozumienia ludobójstwa.
We all are aware about the crimes and mass killings, slaughters in Ukraine, but nobody knows how to resolve the dispute between Ukraine and Russia, and nobody knows how to explain those mass killings and butcheries in Ukraine.
Jednocześnie, jako mieszkanka z Charkowa, mogę osobiście powiedzieć, że rosyjska agresja na Charków rozpoczęła się 24 lutego. Rakieta tornado wpadła pod moje okna, a ciągle z rosyjskimi flagami przyjechali po naszej głównej ulicy, na której się znajduje się nasz uniwersytet.
As a resident of Kharkov, I can witness and testify that the aggression of Russia against Ukraine took place on February 24 when a tornado missile landed outside my building, and which is really close to the university building.
A teraz od kilku miesięcy poruszamy się po Charkowie w poszukiwaniu bezpiecznego miejsca pod nieustannymi dźwiękami syren i wybuchami. W związku z tym naukowcy Ukrainy, polscy i różnych innych krajów połączyli się siły, aby stać czoło złożonym zagrożeniem nadciągłym nad Ukrainą i całym światem.
And since Russian tanks, they arrived to our hometown, we now are living in a constant fear. And when multiple air alarms are coming off and we have to hide all the time, academic community from Ukraine and Poland and around the world join together to find solutions.
I wszyscy nasze badania są nastawione. Dziękuję bardzo, że nie zostawili nas samych. Dziękuję za wysłuchanie.
And all our research and investigations are focused on that one task. And I'm very grateful that you did not leave us alone. Thank you. Thank you a lot.
Дякую, будь ласка.
Bardzo dziękujemy. Thank you very much. I pan profesor Ponomarenko. Please turn on the microphone.
Przepraszam, panie. Thank you very much, Professor Rubel, for inviting me to attend your meeting. I'm very thanks to Professor Kai Ambos for interesting and informative for me your speech, your presentation. And I would like to ask Professor Olena Sharvan I very apologize for my poor English, тому я буду просити вас допомогти мені перекласти з української, якщо ви не заперечуєте.
Ні, тільки говоріть короткими реченнями.
Дуже короткими. Шановні колеги, я щиро дякую за ваш інтерес до нас, до нашої війни проти агресора і до проблем, які ця війна породила в правовій площині.
Dear colleagues, I'm very grateful for your interest to our issues and to legal aspects of this war in Ukraine.
Те, про що сьогодні говорили, більшою мірою стосувалося, переважною, не повністю, але більшою мірою стосувалося питань кримінальної процедури, кримінального процесу, притягнення до відповідальності національної чи міжнародної, але тим не менш процесуальних питань.
Our today's discussion was mostly, not entirely, but mostly focused on criminal procedure with respect to prosecution of crimes and violations in Ukraine.
Я б хотів звернути увагу на питання матеріального, субстантивного кримінального права, бо вони теж дуже важливі в цьому аспекті.
I would like to focus our attention a little bit on the question of substantive criminal law, as those issues are as well very important.
На жаль, той факт, що Римський статут в Україні не ратифікований, це може і велика, але не єдина проблема. Ми маємо ще одну істотну проблему в цій частині.
The fact that Rome Statute has not been ratified in Ukraine yet is one of the biggest issues, but we have another issue that is as important as.
Рік тому, за рік до війни, наш парламент, Верховна Рада, прийняла закон про внесення змін до Кримінального кодексу України, в якому статті про агресію, про порушення законів і звичаїв війни і злочини проти людяності були викладені майже дослівно відповідно до положень Римського статуту.
1 year ago, Supreme Council of Ukraine amended Verkhovna Rada of Ukraine amended Criminal Code of Ukraine, and such crimes as aggression, crimes of war, and crimes against humanity were introduced in the same language as they appear in the Rome Statute.
Але, на жаль, президент рік тому цей закон не підписав і не підписав його досі. Тому закон досі не набув чинності.
Unfortunately, this new law that amended criminal code did not came into effect because our president hasn't signed it yet.
І ми вступили в гарячу, цю широку фазу війни з положеннями Кримінального кодексу, ну, які, відверто скажу, повторювали те, що було ще в радянському кримінальному праві стосовно відповідальності за злочин агресії і за порушення законів і звичаїв війни.
And when the war started, we were left with the same language in criminal court with respect to those crimes that existed way back in Soviet times.
І зараз, коли ця справа, про яку вже багато хто з вас сьогодні згадував, справа російського полоненого солдата Шишимаріна, йому ставлять в вину статтю 428 порушення законів і звичаїв війни, а стаття 428 написана абсолютно неконкретно, абсолютно не відповідає вимогам правової визначеності.
Also, in case of the Russian soldier Shamarin that was mentioned today, his acts are qualified based on old law, which is not well defined and outdated.
І я вже сьогодні вранці читав повідомлення про те, що його захист поставив питання про виправдання його за статтею 428 Кримінального кодексу України через неконкретність пред'явленого звинувачення.
And actually, this is Article 428 of Criminal Court. And today I read an article that that soldiers' defense raised an issue of acquittal because the law is not well defined or vague.
Я так розумію, що українська влада теж усвідомлює проблему, пов'язану з тим, що той закон не був підписаний рік тому. І буквально пару тижнів назад до Верховної Ради був внесений проект нового закону аналогічного змісту про викладення відповідних статей Кримінального кодексу в редакції яка дослівно буде повторювати відповідні статті Римського статуту.
And it looks like that Ukrainian government realized the issue and the problem that was raised because the amendment was not signed by the president. And several weeks ago, there was a bill introduced to Ukrainian parliament that also changes the criminal code and puts those articles in the redaction that mirrors the language in Rome statute.
Звичайно, прийняття цього закону полегшить до певної міри майбутні процеси по злочинам, які виникнуть після набрання законом чинності. Але виникне проблема зворотної дії цього закону до злочинів, вчинених після 24 лютого і до цього часу.
And of course, if this bill is passed, this will resolve the issue of future crimes that will be committed after this law comes into effect. But the question is what will happen with respect to crimes committed before the effective date of this new law.
На завершення, я перепрошую, що задовго говорю, на завершення хочу сказати, що ми в Україні прекрасно розуміємо, що найбільш швидким, ефективним і належним буде національний рівень притягнення агресора до відповідальності.
And I apologize for a long speech, but last thing that I would like to say is that in Ukraine, we realize that most effective and quick will be prosecution of those crimes on the national level.
І ми над цим працюємо, поглиблено працюємо. 2 тижні тому кафедра, яку я очолюю, кафедра кримінального права Національного юридичного університету імені Ярослава Мудрого, провела наукову конференцію всеукраїнську, присвячену саме проблемам реалізації на національному рівні кримінальної відповідальності за воєнні злочини.
And we are working on that issue. And several days ago, we had a conference organized by my department where we discussed how to approach the issue of criminal responsibility on international level for the crimes committed in Ukraine.
Буду щиро вдячний вам за нашу подальшу співпрацю і на сам кінець хочу у вашій особі щиро подякувати всьому польському народу за ту допомогу, яку польський народ, польський уряд надає Україні, українським біженцям, українським солдатам, нашим захисникам, українському народу в цій війні. Ми вам щиро за це вдячні і ми ніколи цього не забудемо. Дякую.
And I hope for future cooperation. And through you, I would like to express my gratitude to the entire Polish nation for all the help you offer and give to Ukrainians, Ukrainian refugees, displaced people, and Ukrainian soldiers. Thank you very much. From you, I would say that I tried my best. Hopefully, I did not miss any points.
Дякую bardzo.
You made it perfectly. Thank you so much, Professor Ponomarenko. for me, it is all the time shocking when we just held a discussion and we are sitting in some places where in the same time there might be bombing on some sirens or alarm or anything like that. That seems like science fiction, telling the truth, like a dream that couldn't be treated as a reality. Thank you so much for your presence, for your commitment and your remarks. Professor Ambos, would you like to take the floor for some final words?
Yes, I also want to thank you. I think we had a very interesting discussion. It certainly took more time than we all had planned. I personally have still to go to my garden to do some garden work. So I think everybody is very tired now and has maybe family obligations or wants to eat.
You used to it.
You used, okay.
Yes, on Friday evening, it normally, you know, in that moment, we have some beer already, but we used to spend this time together.
I didn't know how strict you work in Krakow, Professor Robel. I know now. It's the first time that I spoke at your university, even if it's only online. It was a great pleasure. Also, I want to thank everybody for your patience and all the people who, like Ms. Trendavilova, of course, and others from the KSC, from Göttingen who participate. I want to reiterate my invitation for investigators, researchers. If they want to come to Göttingen, you are always welcome. Dominic is right now. Dominic, maybe you are not in Göttingen, you are in Rostock, but you can inform everybody in Krakow. You know everything. You know the kindergarten. You know all the important places.
Now here is very bad rain and it is not very good place, but in a half hour, I think everything will be okay.
Okay. And also to the Ukrainian colleagues, maybe you have known that there was a specific program by the Volkswagen Foundation to help Ukrainian professors and researchers if they want to stay at a German institution, university, of course. So Professor Ponomarenko or you or your colleagues, we have actually very close contact with Kiev University. A colleague of public law, Professor Mann, Thomas Mann, has very close contacts with the law faculty of Kiev. So we have a traditional contact. But I just wanted to remind you that there is still a possibility of getting scholarships and financing for Ukrainian colleagues who are no longer able to stay in Ukraine. I mean, who really need to leave and can have an interest in certain academic topics. So I think it was a very fruitful meeting. I hope Professor Robel and you are happy with the outcome. We could go on to discuss, but it's always like this. But I think we should now close. I think it was enough time, and it was a great pleasure for me to be with you. Thank you very much.
You took the place of organizer. Thank you so much, Professor Ambos. Thank you very much. A lot of inspirations, and I think that this for me the most important question is what is really the function of the criminal responsibility, and that's unconventional and unnormal situation of war, of aggression, of war crimes that seems to be rather theoretical topics also in our scientific life. Yes, we taught this our students, but nobody thought that we will talk about this as something like a reality that is several kilometers, not maybe several, but some 100 kilometers from the place where we are living. Thank you so much, Professor Ambos, for acceptance and accepting our invitation. We could talk much longer. I hope it is not the last possibility that we will talk about this. I regret so much that Professor Mikola Gnatowski is not with us, though he wanted so much to be. He's a great supporter of the idea of the special court. He will enrich, but still, for all of you, thank you very, very much. President Trendafilova and our German guests, our Ukrainian guests, thank you so much, and I hope to see you once again here on maybe each more real situation, maybe somehow in Krakow University. We met now, we saw each other, so I hope we will meet once again. Thank you very much.